This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you. This is Court of Criminal Appeals for East Tennessee. On the panel today, to my right, Judge Robert Holloway Jr. from Columbia, and to my left is Judge Robert H. Montgomery from Kingsport. I am Kerwood Witt from Monroe County. Would you call our case, please, Mr. Clerk?
State of Tennessee versus Donald Pennington.
Okay. Arguments are 20 minutes per side. The appellant may reserve a portion of that time by announcing the reservation at the beginning of your argument. Okay. So, Ms. Butler, you can proceed.
Thank you, Your Honor. Good morning, and may it please the court. Jessica Butler with the Appellate Division of the Public Defenders Conference. On behalf of the appellant, Mr. Pennington, with the court's permission, I'd like to request 2 minutes for rebuttal.
Okay.
Thank you, Your Honor. Mr. Pennington was convicted of 1 count of rape of a child via digital penetration and 1 count of aggravated sexual battery. For today's purposes, we are only appealing the rape conviction. And we'll actually rest on our brief with regard to the sufficiency. So I'd like to spend most of today focusing on the prosecutorial misconduct argument. There were 2 instances of misconduct in this trial. The first came during the redirect examination of the state's DNA expert. On cross, defense counsel had spent a significant portion of that time discussing the likelihood that Mr. Pennington's skin cells would have been on the victim's clothing if he had committed these offenses. So on redirect, the state doubled back to that point, and the following exchange occurred. The state asked the expert, and he, meaning defense counsel, also asked you about skin cells from the male on the female's bathing suit. If there was, intercourse, I guess in this case she was raped, but intercourse. In that situation, in order for that to happen, ideally, obviously the man would have had to touch the bathing suit. His body would have touched the bathing suit for his skin cells to be on that, correct? And the expert answered in the affirmative. So the portion of that exchange that we take issue with is that aside in the middle, the "I guess she was raped" comment. And for a couple of reasons. I think both the timing and the content of that statement are important. And the state in its brief mentions qualifying phrases that can sometimes be used to potentially cure instances of misconduct. Phrases like "I submit" or "I think." But I do want to point out that typically when we talk about those phrases being used to kind of qualify a prosecutor's statement of their opinion about a certain issue, we're usually talking about that in the context of closing argument, where it's everyone is aware of the fact that prosecutors are given significantly more leeway in closing arguments to make those to make their case as strongly and forcefully to the jury as possible. But that's very different from what we have here. Here, this comment came not in closing argument, but in direct examination or redirect examination of an expert witness, specifically a DNA expert. Obviously, the court is aware of how the lay person views DNA, especially in the context of criminal proceedings. So there's no question that the jury was extremely keyed in to this exchange between the prosecutor and the expert. And again, we have not just the prosecutor giving their opinion about, say, a collateral issue at trial, but really the prosecutor is giving her opinion about the ultimate conclusion of this trial. It's not just that she's giving a comment about credibility of witnesses. She's actually signaling to the jury that it's her determination already. It's a foregone conclusion in her mind that the victim was raped. And that is the sole reason that this jury panel was brought was impaneled to decide whether or not, based on the evidence, the victim was raped. So for the prosecutor to then, in the midst of a question, to essentially treat that as a foregone conclusion, it not only takes that determination out of the jury's hands, but obviously it prejudices Mr. Pennington, because the jury they're listening to the prosecutor with all of the weight and authority and credibility that position holds. And the prosecutor has already signaled in her mind, and then with the tacit kind of acceptance of that statement from the DNA expert, it's already a foregone conclusion in the prosecution's mind that Mr. Pennington was raped. And essentially, there's no reason for the jury to reach any conclusion because the prosecutor's already supplanted her own opinion for that of the jury. And I do want to point out that the evidence here, this was a very close case, specifically with regards to count one, which is the digital penetration. As I said, there was no DNA evidence, so the jury was relying solely on testimony from witnesses. There were some slight inconsistencies. Again, it was just a very close case. So I think the fact that the jury ultimately reached a decision on rape of a child in this case, I think we have to look at the impact that statement from the prosecution had on the case moving forward. But I think whatever harm...
Mr. Butler, there was no contemporaneous objection to that question by the prosecutor?
There was not. So we are under plain error here. And I do understand the heightened standard, but I think even with that standard, the harm and the prejudice to Mr. Pennington is clear here. And I think that whatever harm occurred from this statement was then compounded by what happened the next day in closing argument. And that's the second instance of misconduct we have. In closing argument, the prosecutor was attempting to explain to the jury the legal standard for penetration, that penetration, regardless of how slight, was still penetration and thus was enough to sustain a conviction for rape of a child. And if the prosecution had stopped there, we probably would not be here on this issue. Unfortunately, what happened is that the prosecution went on to say that it was not necessary for Mr. Pennington to, and this is a direct quote, to completely destroy the victim's vagina. So not only is the statement unnecessary, uncouth, and really has no place in the courtroom, and I actually would like to push back on, the state characterizes it as a rhetorical flourish. And I think that it is much more significant than that. We're talking about an adult male on trial for rape of a child of an 11-year-old victim. That statement has no place in this kind of proceeding. That statement evokes a violent and assaultive imagery. It really ratchets up the perception about what this case is really about. It no doubt inflames the passions of the jury and really paints Mr. Pennington in a very different light than was already occurring in these proceedings. That statement, it served no additional purpose. Obviously, without that statement, the jury was aware of the slight penetration standard. So there was no reason to continue. But by doing so, as I said, the state inflames the passions of the jury and really takes this to another step. It becomes a conversation about, as I said, a violent assault instead of the actual evidence at hand. And so to discuss this event in that manner, again, we have an 11-year-old victim. So it's really personally detrimental, not just to the victim, but I think legally prejudicial to Mr. Pennington. And again, we are under plain error here, but that kind of statement, specifically, again, the timing here I think is important. That statement came in the state's rebuttal close. So this is one of the last things that the jury hears from the state. This is after Mr. Pennington has had any opportunity to discuss, to come before the jury. There's no opportunity for Mr. Pennington's counsel to rehabilitate him, to have a discussion about that statement, to try to diminish the impact of that statement. This is one of the last things that the jury hears from the state before they go back to deliberate.
Ms. Butler, one more question. These two,
yes,
the comment and the question, first of all, and then the comment in closing by the prosecutor, were they directed to both of these incidences or just to count one or count two?
I think it's a fair reading to say that they were addressing both. Particularly, I think the question really goes to both. because there's discussion of if he touched the bathing suit and then if a body part touched the bathing suit. So I think definitely the question goes to both counts. But I also think it's a fair reading to say that the comment in closing also goes to both points. Although I would say it's difficult to tell because certainly with digital penetration, as I said, it's a closer call. So the discussion about what constitutes penetration and however slight, I think that probably goes more to the digital penetration count than the penile. But I do think that it's a fair reading to say that it's both. So as I said, given that this was a close call, particularly on count one, and this is one of the last statements that the jury hears, I think either statement on its own, the question and the statement in closing, I think either are prejudicial, but I think collectively they do create a situation, they create a harm that's really too prejudicial for Mr. Pennington to overcome. So whether the court decides that collectively they are harmful error or separately or one or both, I think both are harmful, but I do think that the collective nature of the two really brings us to a point where even under the plain error standard, the prejudice and the harm to Mr. Pennington and his ability to receive a fair trial from this jury is clear. So we would ask the court to reverse and remand for a new trial based on that. And I do think I'm getting a bit short on time. So just very quickly, I want to address the sentencing issue. The trial court imposed consecutive sentences in this case. In its own words, it said that they were crimes against nature involving sexual conduct. And that's not quite the wording of the statute, but I think it's clear that what the court was getting at was that these were two crimes involving sexual contact with a minor, and thus they were eligible for consecutive sentencing. But simply because they're eligible does not mean that consecutive sentencing was required. But what was required was for the trial court to put some type of finding on the record about why and how it reached its decision to impose consecutive sentencing. The simple fact that consecutive sentencing was on the table doesn't necessarily mean that it was necessary or appropriate. And the trial court at the sentencing hearing goes through a pretty lengthy discussion of probation, of the principles of sentencing, and the need for incarceration in this instance. But Mr. Pennington was not eligible for some type of sentencing alternative. This was always going to be a sentence that he had to serve in incarceration. So that discussion is really ancillary to the ultimate decision about what the sentence should be and if that sentence should be served consecutively. But again, when we got to the section in the hearing where the court was discussing whether consecutive sentencing was appropriate, all that we heard from the trial court was that these were crimes against nature involving sexual conduct, and thus the trial court was imposing consecutive sentences. And so the court, I think, just missed a step, didn't quite show all of the work here. And so it leaves both Mr. Pennington and the state, as well as Your Honors, wondering why the court decided that consecutive sentencing was appropriate over, say, a concurrent sentence of 30 years. So on that basis, I think the court obviously can conduct a de novo review and reach its own conclusion about the appropriateness of the consecutive sentence. But I think a de novo review is required here because the trial court just did not place its findings on the record. We have no indication about why the trial court decided 40 years was more appropriate than 30. So we would ask the court to do that de novo review, and of course ask that the court reverse that decision and order concurrent sentencing. And if there are no other questions, we will rest and turn it over to the state and await rebuttal. Thank you, Your Honor.
Thank you. Yes, General.
Good morning again, Your Honors. I may it please the court. Alan Gross for the state of Tennessee. A jury determined that the defendant in this case raped his stepdaughter by digital penetration and the jury acquitted the defendant of rape by penile penetration, instead convicting him of the lesser included offense of aggravated sexual battery. And as my colleague on the other side has mentioned, she's raised 3 issues: the sufficiency of the evidence, allegedly whether the trial court committed plain error in allowing certain comments by the state during its case in chief and during its rebuttal closing argument, and then finally, whether the court abused its discretion by ordering consecutive sentencing. So because the defendant has decided to rest on the briefs for the sufficiency issue, I also will primarily focus my arguments on those latter 2 issues. As the defendant concedes, the issues about the state's comments during its redirect examination of Special Agent Lowe and its comments during closing rebuttal arguments, those were not objected to in the trial court, so we are under plain error review. So this court has discretion whether or not to even address this issue. This court is certainly not obliged to engage in a plain error analysis. But if it chooses to do so, it should find that the defendant is not entitled to relief. First, the state did not breach a clear and unequivocal rule of law in either instance. First, let's take the comments during redirect examination of Agent Lowe. The defendant argues that the prosecutor was commenting improperly on the ultimate issue in the case of the defendant's guilt by saying, well, in this case, I guess she was raped. And I think context just completely dictates otherwise. No reasonable juror that was listening to that very long-winded, complicated question would have thought that the prosecutor was trying to leverage her experience in law enforcement to convince the jury that she knew the defendant, in fact, was guilty of rape. It was clear that the prosecutor was trying to ask a question rather than making a statement, and that in the midst of that question, she rephrased and used the word rape instead of intercourse, since that's the allegation in this case. So I really don't think that this was a breach of a clear and unequivocal rule of law at all. And in fact, if you pay attention to the witness's response to that question, the response actually hurts the state's case. The prosecutor was asking, essentially, if the defendant had raped the victim in this manner, wouldn't there have been skin cells on the victim's bathing suit bottom? And the witness says that is correct. And so that actually hurts the state's case. It's really strange that the defendant is arguing that this was actually prejudicial. In fact, it cuts the other way. And with respect to the comments during closing, the rebuttal closing arguments, the defendant's trying to say that the phrase, he didn't have to completely destroy her vagina, was lewd and inflammatory. Those are the words used in the defendant's brief. But as this court knows, there's nothing lewd about using the word vagina or any other sexual organ in a rape case. And it's not inflammatory either. I mean, the state was simply trying to highlight the legal standard of slight penetration. And that's all that's required. And this court has repeatedly held that the state and the defense counsel is allowed to use colorful and forceful language during closing arguments. The court affords a lot of discretion in that regard. And the court's also required to interpret closing arguments by looking at what preceded it, by looking at the defense counsel's closing arguments and seeing how that explains why the state and its rebuttal is saying certain things. So when the defendant is trying to downplay the legal standard of slight penetration, the state is well within its right to use forceful language to remind the jury what's really required under the law. So the state's position is that neither of these comments violated a clear and unequivocal rule of law at all. And even if it did, the defendant has failed to show that either of these remarks adversely affected his right to a fair trial, which is another factor that's required under plain error review. And for the reasons I kind of already discussed during redirect examination, the statement that the prosecutor made actually, helped the defendant because the witness responded to that question by saying, yes, if there was, a rape in this case, we would expect to find some kind of DNA evidence when there wasn't any in this case. So that it wasn't prejudicial to the defendant. And the defendant in his brief kind of suggests that the way this question was asked and answered, the jury would have thought that the witness was agreeing with the prosecutor that the victim was raped. And I just think that the context just does not permit that inference. And I just don't think that this is a very prejudicial comment, such that it would have affected the outcome of the trial. And as I mentioned in my brief, the jury's also instructed at the end of the trial, as it was in this case, that comments and questions by counsel during the case in chief or during closing arguments are not to be considered as evidence. The jury is supposed to disregard them. And so to the extent that it was prejudicial, the jury, was instructed to disregard it. And this court's required to presume the jury followed the instructions that were given to it by the trial court. So that's another reason why this did not affect the outcome of the case. The defendant concedes in the brief that the remark during rebuttal closing arguments was not enough standing alone to change the outcome of the trial. That's clearly stated in the defendant's brief. And the reason for that is because there's a jury instruction that tells the jury closing arguments by counsel are not evidence. Just like there's a parallel jury instruction for disregarding statements and questions by counsel. So the defendant's trying to assert that these remarks during closing might have affected the outcome of the trial when considered in combination with the statements during redirect. But that's essentially a cumulative error argument. But the defendant has not raised the issue of cumulative error in the statement of the issue. So that argument is just simply waived. And it's also without merit because, like the defendant apparently concedes, there's a jury instruction telling the jury not to consider statements made by counsel during closing arguments. So whether viewed independently or together, neither one of these statements that were cherry-picked out of this transcript would have affected the outcome of the trial. I want to make a third argument on plain error that is not in my brief, but of course, if this court were to conduct a plain error review, it would be required to go through each of the 5 plain error factors, and defendant would have to successfully persuade the court that all of the factors were satisfied. And one factor I didn't address in the brief was whether this issue might have been waived for tactical purposes. And I think clearly that's the case here because, apparently these comments, if the defense counsel and the trial court noticed them at all, chose not to object, likely because objecting would draw more attention to these comments that are allegedly inappropriate. So under plain error review, the defendant's not allowed to tactically waive an objection in the trial court in the hopes that it'll work out in the end and then raise the issue on appeal and expect plain error review. So this court should consider that, the defense counsel's actions in the trial court were likely tactical if, this was perceived as an issue at all. If there's not any questions about this plain error review of the prosecutor's comments, I can turn to the issue of consecutive sentencing. So as an initial matter, the trial court sentencing decision is presumptively reasonable and should only be reviewed for an abuse of discretion. The trial court did identify the statutory basis for ordering consecutive sentencing. It specifically said on pages 63 and 65 of the sentencing hearing transcript that the reason it was ordering consecutive sentencing was because the defendant was convicted of 2 statutory offenses involving the sexual abuse of a minor, which is one of the 7 reasons that you can order consecutive sentencing. Now, the defendant is trying to argue that the presumption of reasonableness should not apply simply because the trial court did not also make specific findings at that time about the aggravating factors that are also listed in subsection 5 of the relevant statute. But in State versus Church, which this court decided in 2016, relatively recently, the trial court doesn't have to specifically discuss those aggravating circumstances for this particular ground of consecutive sentencing in order to trigger the presumption of reasonableness and the abuse of discretion standard of review. So under Church, it's sufficient to simply identify that you're ordering consecutive sentencing because the defendant was convicted of 2 statutory offenses involving the sexual abuse of a minor. And even if this court were not inclined to follow the holding of Church, the trial court clearly made these findings, at least some of them, elsewhere in the transcript during the sentencing hearing. Primarily, when the court was discussing enhancement factors, the court noted that the defendant abused a position of private trust, which is an enhancement factor for the length of the sentence. That also is a factor that applies to the aggravating circumstances relevant to consecutive sentencing, being the relationship of the defendant to the victim. So the court clearly made a finding about that fact elsewhere in the sentencing hearing. The court also kind of alluded to the victim's residual mental damage by referencing the mother's testimony at the sentencing hearing that the defendant, when she invited him to come into her life, was supposed to protect the victim and not scar her forever. And there was some testimony at the sentencing hearing about the victim struggling with some mental health issues in the months and years following this incident. So even if the court were not inclined to follow Church and would require specific findings about these aggravating factors, the court still made some of these findings elsewhere during the sentencing hearing. So the state's position is that the presumption of reasonableness does apply, the abuse of discretion standard applies, and under that standard of review, the court clearly applied the correct legal standard, and the evidence that relied on was not clearly erroneous. The defendant's not disputing that he was convicted of 2 statutory offenses involving sexual abuse of a minor. He's not disputing that he was the victim's stepfather. He's not disputing that the victim experienced residual mental damage. He's not disputing any of this. So the evidence wasn't clearly erroneous in that regard. And as defense counsel, mentions today, if this court chose not to apply the abuse of discretion standard of review, it could still conduct a de novo review. And for all the reasons that I've previously mentioned, it would be very easy for this court to affirm on de novo review instead of remanding to the trial court for another sentencing hearing. It's very apparent what the relationship was between the victim and the defendant. There's undisputed testimony regarding the other aggravating factors as well. So if there are no further questions about this issue, either the state would respectfully ask the court to affirm the judgment of the trial court.
All right, thank you. Rebuttal?
Thank you, Your Honor. The state in its discussion talked about context, the context of this question and the answer from the DNA expert, and said that basically the answer that was given cut against the state. And I do think that the context is important, and the fact that the answer cuts against the state, I actually think makes this comment a bit more insidious. That the state, was asking a question, the answer was clearly yes, and that's a bad fact for the state. And so for the state to kind of slip in this comment about, well, I guess she was raped, again, as if it's a foregone conclusion, at that particular point, I actually think that makes it a bit more insidious than if, this were a question that actually, the response actually benefited the state. The state also said that we conceded that the statement in closing argument was not enough. I think that we said the statement may not be enough on its own, because again, we are under plain error here. Personally, I think the statement is enough, but given the heightened standard, I think it's possible that statement alone is not enough. Nonetheless, I think the statement, again, compounded with the question on the previous day, that absolutely is enough to be prejudicial to Mr. Pennington. As for the jury instructions that were received, as the court well knows, even in instances where the jury is instructed not to consider the comments or statements of counsel, this court has still found, even under plain error, that those statements can be prejudicial and can have an impact on the trial. So the simple fact that the jury was instructed not to consider the statements of counsel, that's not necessarily enough. We still have instances, there are many cases where the court looks at it, even under plain error, and says, the jury was instructed not to consider the statements of counsel, but the statement was nonetheless prejudicial and had an impact on the outcome of the trial. Again, timing is important here. The jury was instructed not to consider the statements of counsel a full day after they had already heard this statement from the prosecutor on the previous day. So they've had a night to sleep on it, they've had a night to digest it, and then a full day of testimony before they're told, oh, by the way, don't consider statements of counsel. That's very different than a situation where right before, right after closing argument, they're told, these statements are not evidence. That's a different situation. They've had time to ponder it. It's kind of already, the damage is really done by the time we get to the next day, and the court is telling the jury not to consider the statements of counsel. They've already heard the statement. They've already made an assumption on the statement one way or the other. So the harm is really already done there. As for the sentencing issue, I think there has to be more than a stream of consciousness that kind of ultimately winds up at the right conclusion. That even if the court addressed some of these issues sort of in a previous discussion about something really unrelated to the matter at hand, to a collateral matter, the enhancement factors, even if the court has addressed some of these issues, there's no connection tying it back to the need for consecutive sentencing. At no point did the court actually make it clear why 40 years was more appropriate than 30 years. That's the ultimate problem here, is that there are pieces of discussions that happen, but there's never a connection that says the court has determined based on X, Y, and Z, 40 years is more appropriate than 30 years. And that's really where we have the issue, and that's where the error occurred. Again, the court is able to conduct a de novo review and very well might reach the same conclusion. It's still error nonetheless that the trial court kind of had this meandering thought process and then ultimately came to a decision for a reason that's not clear from the record, that the 40-year sentence at 100% was more appropriate than the concurrent sentence of 30 years. With that, we'll rest. We'll ask the court to, of course, reverse and remand for a new trial, but at the very least, to reverse the trial court's decision with regard to consecutive sentencing. Thank you, Your Honor.
Thank you. Thank you both for your arguments today. This concludes the argument in this case, and we will be in recess until 2 o'clock, I believe.
The court is now in recess until 2 p.m.